that we're not outside. um, we appreciate your being here. It's been kind of quite a week, but today we really want to talk about fossil fuels and dirty energy and the work that we're doing. We want to just make sure that you have an opportunity to hear about what MEIC is doing and also to ask questions about it. But we're feeling pretty lucky because we do have Melissa Hornbein here tonight. She's with the Western Environmental Law Center, who is a scrappy, wonderful public interest law firm that does really all of our work on oil and gas. They are our attorneys on so many fossil fuel related issues. And most recently, just as a shout out to them, they have done an amazing amount of work on the what's colloquially called Youth v. Gov, but it's really called Held versus the state of Montana, in which the younger generation is suing the state of Montana over its failure to do anything on the climate crisis. And it's an amazing body of work that they have put together with a couple other attorneys. But one of them is our MEIC's board member, Roger Sullivan, who many of you might know. Roger has been a leading environmental attorney in the state for so many decades, and such a wonderful person. But Melissa and WELC have been working really hard on that case. And when everything gets filed, I would highly encourage you to read the filings of the experts, because there's some really amazing work and information in there. But one of the things that I pulled out from one of the experts was this statement: the total CO2 emissions associated with Montana's fossil fuel-based economy are on the order of 166 million tons of CO2 being released into the atmosphere annually. 166 million tons. That's from everything we do. That's oil, gas, coal. It's transportation. It is elimination of the overlap between all these things. It is what an expert has found Montana's annual emissions are. And Montana, our emissions are about equivalent to countries, entire countries like Argentina and the Netherlands and Pakistan have emissions equal to this. So the state of Montana has an enormous carbon footprint, and we can't do anything about it until we start to transition away from fossil fuels. So that's what we're going to talk about tonight, in addition to talking about nuclear technology. But we're going to start by giving Melissa Hornbein the floor, and she's going to give you an update on oil and gas activities in the state. Melissa, it's all yours. And I will stop sharing my screen so you can, if you have it. Yeah.
Thanks, Anne. And hi, everyone. And before I start talking oil and gas, I just want to point out that the Held case that Anne was just talking about, she is one of our experts for, and like I've known for years how awesome Anne is, but I just read her expert report for this as we were preparing to file it for this case. And I was like blown away by how much I didn't know and how much she does know. She's just like a guru on all things energy, going back decades in Montana. So I was already in awe of Anne, and I'm even more so now. So just wanted to flag that. And we currently have a trial date in that case set for February of next year, and Anne will likely be on the witness stand. So everyone should show up and cheer her on when that happens. So I'm just going to give a really brief kind of update on the state of the land, so to speak, with respect to the federal oil and gas program. Federal fossil fuels contribute about 25% of all United States fossil fuel production or greenhouse gas production. And so it's a very significant source of greenhouse gas emissions, climate damage, public health causing methane related pollution, and a number of other things as well, including on the ground disturbance and impacts to the environment that I think all of us value so much about Montana. And in our oil and gas work at WELC, we really focus on the federal system precisely because it is such a big piece of the pie. but also because we have great tools like the National Environmental Policy Act to go after the decisions that the federal government makes to allow this kind of development on federal lands, despite the fact that the science tells us very clearly that we cannot do more fossil fuel production, period, and maintain any chance of staying below 1.5 degrees Celsius of global warming. So I just prepared a few slides. I'm going to try and make this really short, and then if there's time, folks are welcome to ask questions. And now I just have to figure out how to share my screen here. Hang on. All right. Sorry, I'm sort of a Luddite, so I'm slow with this.
Your good attorney will forgive you being a Luddite.
Share screen. There we go. The big fat green button right in the middle. Okay, is everyone seeing a PowerPoint slide?
Nope.
Not yet.
How about now?
There it is.
There we go.
Okay, perfect. So just to provide a little bit of context, the work we do in Montana on federal oil and gas leasing in particular, almost invariably with MEIC as a critical partner, is really targeted at all stages of federal oil and gas production. And that basically involves 3 main stages. The first is planning, and that is really broader than oil and gas per se. The Bureau of Land Management is required to undertake land use planning under the Federal Land Policy and Management Act for given planning areas, which in Montana are millions of acres. So it's really big chunks of land every 20 years. And so at the planning stage, basically they're saying, this is what's allowed, this is where it's allowed. And so the planning stage decisions are enormously important in terms of how much ultimate oil and gas production they allow pursuant to that plan, because any land use management that takes place within this millions of acres planning area has to comply with the land use plan that's promulgated under the Federal Land Policy and Management Act. The next stage is the leasing stage, where the federal government holds oil and gas leases, and companies bid on them. And if they are the successful bidder, then they have that lease to develop for a period of 10 years, although the reality is that that period of time often gets extended with little to no administrative oversight. And then the last stage is what we call the drilling stage or permitting stage, and that's when the wells actually get drilled. And on the slide, the notes that I have here is sort of the baseline for what courts have held is required. So for a number of years at the planning stage, the Bureau of Land Management would say, oh, we can't talk about climate change, we can't talk about greenhouse gas emissions because it's too speculative. We don't know where lands will be leased, what will be drilled. And courts have said, no, actually, when you're deciding what can happen on a large piece of federal land, you're doing so with the expectation that that will happen. You use economic predictions to determine how much money you're going to make in revenues. And if you can use that kind of data to make revenue predictions, you can use the same data to make combustion and greenhouse gas emission predictions. So that's sort of a lot of the things we've litigated on at the planning stage come back to this question of what the government has to look at before it engages in a 20-year long land use plan. At the leasing stage, it's what courts have called an irretrievable commitment of resources. And that's only important because it triggers the requirement for the government to conduct an environmental analysis of the impacts of that leasing action under the National Environmental Policy Act. And then at the permitting stage, a lot of times what the government will do is it'll go back to its land use plan and say, oh, we've done all the analysis we need to do. We're just relying on this land use plan. And to some extent that's allowed, but oftentimes what courts have said is that they have to do more than that. They have to look at what's actually going to happen under that drilling permit in terms of emissions. And all of these cases are, well, many of these cases are notable because MEIC has been involved in many of them. And these cases really have set the stage for what courts have said the government has to do before it can approve a land use plan, issue leases pursuant to that plan, and then actually drill the wells. And part of what this has really evolved a lot over the last 10 years, and the bar has been considerably raised on the government in that time. And a lot of what it boils down to is that through this gradual progression of cases going back to about 2013, when courts were saying, oh, government, all you have to do is basically list the greenhouse gas emissions that you're going to produce, that will be produced from drilling the wells on these leases. And now that holding has really come into question, and a number of courts have said, no, government, you can't just talk about the greenhouse gas emissions from drilling those wells and producing that federal oil and gas. You also have to talk about the downstream impacts. In other words, once that gas or oil is drilled and piped off the lease site somewhere else, it's ultimately going to be combusted, and that combustion is what accounts for the vast majority of the greenhouse gas emissions from federal fluid minerals. And you can't just ignore that. You have to analyze that. And then most recently, we've had some really good decisions, both in the context of oil and gas litigation and coal, that have said, you can't just talk about emissions, government. You have to actually talk about what that means on the ground. But courts haven't said exactly how much more, like what that next step is, how much more the government has to do than just putting a number on the emissions. And so that's what a lot of the cases that we're involved with MEIC on now are centered around, is trying to raise that bar even more. And so that the government really has to acknowledge the on the ground climate and other impacts of its actions in perpetuating this federal fossil fuel leasing program that's so detrimental both to our environment in Montana and obviously to global climate health as well. That was basically up until December 31st of 2020, or I guess actually January 19th of 2021. There have been a number of actions that the current administration has taken that initially gave us a lot of hope that things were really changing. I mean, you know, I think we're all aware of the fact that President Biden on the campaign trail promised no new federal oil and gas leasing, no more fracking on federal lands. That obviously has not transpired, but when these executive actions that took place in January of 2021 were announced, we were really hopeful that that is where we would end up. These executive orders did really a number of really critical things. Some of the most important in terms of climate analysis within the federal fossil fuel program were that they reestablished what's called the social cost of carbon, or the social cost of greenhouse gases, and the interagency working group that promulgates it, which is basically a way of monetizing climate damage. And it's something that the Trump administration basically abolished under its term. And it was the interagency working group that creates this metric was established under the Obama administration. This executive order reestablished that working group and then proceeded to tell it that it needed to set numbers that the government would have to use both in rulemakings, but potentially also in things like federal oil and gas leasing. Executive Order 14008 was sort of the really big one from our perspective, or we thought it was going to be. It instituted what was termed a pause on federal oil and gas leasing, pending completion of a comprehensive review and reconsideration of the federal oil and gas leasing program. So we thought that this was like the beginning of the end. We were probably really naive, but that's what we were all hopeful for. And in pursuance of both of these executive orders, Interior Secretary Holland issued Secretarial Order 3399, which established a climate task force. It prescribed guidelines on the implementation of the National Environmental Policy Act, which had been gutted under the Trump administration. And it did something really critical, which is that it prescribed use of that social cost metric outside of the rulemaking context. So to other federal actions besides rulemaking, which is really important for our work, because a lot of what we're trying to do when we sue the government over these leasing or permitting decisions is say, you are not looking at the climate damage and what that's going to cost monetarily and otherwise down the road, you're only looking at present profits. So these executive orders were really critical, but of course they were immediately challenged by industry. In fact, the day after the executive order 14008 was announced, it was challenged by industry in the District of Wyoming. So right now we have all of this litigation against the Biden executive orders tied up in federal courts in 3 different districts around the country. Those cases are all in the process of working their way through the courts. But the question becomes, like, what happens while all this is being figured out? I mean, obviously, once this litigation resolves, we'll have some answers in terms of what comes next. But a lot of what's happening in the cases that industry has filed against the administration is that they're all in sort of a defensive posture, and WELC and MEIC as well have intervened on behalf of the government to defend those executive orders. But unfortunately, there's nothing in those orders that like really advances the ball. It just provides some good language that will allow subsequent actions to be taken. So for example, BLM is in the process of engaging in rulemaking, both with respect to limiting methane emissions from the federal oil and gas program. And for those of you who aren't aware, methane is an incredibly potent greenhouse gas that's about 87 times as potent as carbon dioxide in the near term, over about a dozen years. Carbon dioxide lasts a lot longer in the atmosphere, but if we want to have a reasonable chance of staying below 1.5 degrees Celsius of warming, methane emissions are really the low-hanging fruit of that. So we're hoping for some good rulemaking from both BLM and the EPA actually on oil and gas associated methane emissions. The administration is trying to correct many of the, I won't even say errors, the deliberate destruction of the National Environmental Policy Act rules. So that's an ongoing rulemaking process that will influence the work that MEIC and WELC do going forward in this area. And then there's also future litigation. Because of the litigation over President Biden's executive orders that I addressed previously, ultimately the government decided to hold some lease sales. There was a bad decision in one of the cases challenging the executive orders, and the government interpreted that decision as saying that it had to hold lease sales. So right now the government's planning to hold lease sales in 8 different states on between June 16th and June 28th of next month. MEIC, along with a number of partner groups, have filed protests against those lease sales, and we plan to file litigation almost immediately as soon as those sales have concluded. And I think that what the administration has tried to do here, and they've succeeded in pissing off both sides, but what they've tried to do is take a more nuanced approach to federal oil and gas leasing, because they drastically reduced the acreage amount of these sales from what they had initially announced. So industry is very unhappy about that. Some sort of more reform-minded environmental groups are pretty happy about the reduction in acreage. We are not in that boat, and I think I can safely say that MEIC isn't in that boat either. We sort of view ourselves more as in the abolitionist camp when it comes to new oil and gas development, because the science is very clear that even future oil and gas and fossil fuel emissions that are already committed through, for example, existing federal leases will push us past 1.5. There's just no room for more leasing. And so it makes it very easy from our perspective to make a compelling argument, because the science is really clear on that. There's really no equivocation. And so we will be challenging the June 2022 lease sales on those grounds and saying, look, that it's absolutely arbitrary that you have done all this work, because the Biden administration has done quite a bit of work to look at the greenhouse gas impacts of the federal oil and gas program, much more than really any other administration previously. And yet they've still concluded that they can go ahead and conduct oil and gas leases, and we beg to differ. So that's kind of where things will be going over the next few months. And there's a lot of these rulemakings currently in play. There will be opportunities for public engagement on those rulemakings. And so I encourage people to stay in touch with MEIC and get involved in those. And yeah, I'd be happy to take any questions if there's time for that. Thanks, everyone.
Thank you so much, Melissa. She's just doing a powerful amount of work on the upstream side of the oil and gas sector. And I know she has a family life and kid, a small child. So if there's any questions, let's have them now. And then we will excuse Melissa for the rest of the evening if that's, if that works for her. Thank you, Melissa. Are there any questions?
There's nothing that silences a room faster than talking federal oil and gas leasing. Thanks, everyone. I'm going to mute myself and turn my camera off so I can make dinner for my kid, but I'll be on and I'm happy to take questions later if people think of things later, or you can email me or whatever.
Thank you. And a huge thanks to WELC, who has committed so many resources to helping us in Montana and has for so long. So thank you. And I'm just going to quickly close out the oil and gas issue with a very brief update on what's going on with Northwestern and its gas proposals. We know that Northwestern is interested in building a lot of new gas plants. How many is certainly open for debate, but we know that it's about 800 megawatts worth of gas that it had in its resource plan. Its first one was the Laurel Generating Station, which Northwestern now calls the Yellowstone County Generating Station. We lost the debate before the county commission about a month ago on the pipeline going underneath the Yellowstone River at exactly the wrong location in a river. It will be a future problem, particularly for the poor folks who live next door to that pipeline. Northwestern put it right next to homes and under one of the widest stretches of the river possible, where there is an awful lot of erosion that is occurring. And the commission just ignored that. Then we had an unfortunate memo from the county attorney a couple weeks ago, in which the county attorney said they don't have to get a rezone for that property that they want to build the plant on from the city of Laurel. And that is something that has been an obstacle for them for quite some time. And everybody, including both planners from both the city and the county, were in agreement that they had to have rezoning conducted by the city of Laurel. And the city attorney just reversed course, and in a really shocking and I think poor memo said that it's actually the county's job. And the county is not our friend here. So we're desperately trying to find a hook on that gas plant. Northwestern is commencing construction, what we've heard, on the unzoned section, which they certainly are allowed to do. But right now, it is unclear how we are going to be able to stop that plant. And the folks out there are pretty sad about that. It's just it's a tragedy. That's all I can say. Northwestern is beginning the resource procurement plan. The planning process. Ian Lund on our staff is participating in that process, and he's going to keep everybody apprised. Right now, they're just talking about what is it that Northwestern's going to model, and we know that Northwestern is going to model, sounds like at least a little bit better on renewables and storage, but it's also going to model nuclear. But more to come on Northwestern's modeling over the course of the next few months. And I expect there'll be a public comment period in the fall, and we'll keep you posted on that. I'm going to now move to Derf, who is going to cover our coal work, our coal mining work. And there's a lot of it. So he's been trying to winnow it down, and we'll see how it goes. But please ask questions if you have any for clarification. Derf, it's all yours.
Hi, everybody. I am just needing to allow for Zoom to share my screen. So unfortunately, this is annoying.
It's the big green button, Derf.
No, it's a new computer and
Hmm.
there's a setting. I think I found it here. Just need to.
Whenever you get something new, it's like, oh no. It's
Yeah.
not you have this cool new gadget, it's that you have to start all over again. Trying to figure out how to make it work.
Oh. Okay. In the right spot now. I'm gonna have to quit and log back on in order to share my screen. I'll be just a minute. Apologies. Didn't know this was gonna come up.
Well, then while you're doing that, I'm gonna just cover Colstrip quickly. So while Derf is doing that, I'll do the rest of coal, which is the generation side of the equation. As a lot of you have heard, Colstrip plants operator and part owner, Talon Energy, Talon Montana, Talon Energy, declared bankruptcy last week. And that bankruptcy throws everything into chaos. What's super annoying about the bankruptcy is while Talon was convincing the legislature last session to change all of the laws that govern all the contract language that govern ownership decision-making at Colstrip, Talon was preparing for bankruptcy. So last session, when Talon was talking to legislators about how wonderful everything was and how committed it was to Colstrip, it was hiring bankruptcy counsel to help it initiate the bankruptcy process. So Talon's been working on this bankruptcy filing for over a year. They are $4.5 billion in debt. Last summer, they decided to move into the cryptocurrency market in order to try to raise some quick cash. Turns out that didn't work out so well. And now what we know, there's an article, great article in the Billings Gazette today, that the pensions of some of the workforce of Talon's are in jeopardy. Talon has been suing PP&L, who created Talon out of whole cloth to get rid of all of its, PPL had good assets that it was making money on and bad assets that it wasn't making money on. And in 2015, PPL formed Talon, put all of the bad assets into Talon Energy, and surprise, surprise, Talon doesn't have money for, according to its filings in the court, it doesn't have money for pensions, doesn't have money for cleanup. It is absurd. And so there's a question mark on whether Talon is going to be able to honor its commitments. So the pension article that Tom Ludy put in the Billings Gazette today raises a lot of really important questions. Talon today at a hearing before the Legislative Committee, Energy and Telecom said, oh, everything's fine. Everything's fine. But yeah, it told us everything was fine last year when it was hiring bankruptcy counsel. So take that with a big fat grain of salt. And DEQ stood up today and said, don't worry about the ash ponds. We have plenty of money. Ignore the fact that we decreased their bond by $120 million last year and told everybody, don't worry, we'll just keep getting money from them over time and update their bond every year or 5 years. Well, if Talon doesn't have any money or Talon doesn't exist, who is going to pick up the tab for Talon's share of cleanup in those ash ponds? And the answer is the rest of the owners. And that means you and me, anyone who's a Northwestern Energy customer could be on the hook for a bigger share of cleanup of the ash ponds if Talon cannot fulfill its obligations. And DEQ just keeps saying, don't worry about it. We've figured this out. We know exactly how much they owe. But DEQ does not know how much they owe. DEQ has lowered their bond. DEQ has let them experiment with different technologies to figure out cleanup and said, if that technology doesn't work, then we'll reanalyze it in a couple of years and then we'll increase your bond then. It is really overwhelming that we are at this point again with an agency that can never seem to get bonding right. And now we have a bankruptcy that really throws things into jeopardy. And then the last piece is, how does Colstrip end? Well, in Talon's bankruptcy filing, I'm just going to read you this quote because I think it's really instructive. While Talon's telling the legislative committee that it is committed to Colstrip and coal for the long term. This is what they told the bankruptcy court. Today's electricity consumers, businesses, and technologies demand electricity that is not only low cost, but is also reliable and zero carbon. In response and recognizing this dilemma, the debtors, Talon, began investing in additional carbon-free power projects and complementary battery storage. Each of the projects listed above are part of the transformation of the company's assets and business model towards a decarbonized future. They have a whole section on Talon's transition strategy, but yet it's still telling the Montana legislature that it has no intention to do anything differently at Colstrip. It is disingenuous at best. And Talon is preventing arbitration from occurring and trying to use bankruptcy to prevent arbitration from occurring amongst the owners. All the owners except Talon want to use a provision in the ownership contract between them all to arbitrate to figure out what vote is necessary to close the plant. You know, who gets to make the decision on closure? And Talon refuses to let that arbitration go forward during bankruptcy. There's going to be a hearing in early June before a court with the other owners saying, come on, let us arbitrate, let us get there. And Talon saying, no, we got to let bankruptcy finish. And bankruptcy can take a very long time. And then Talon had the audacity today, sorry, I'm taking too much time on this. They had the audacity today to say, even though we're $4.5 billion in debt, everything is great because we've worked out a deal with some of our creditors and they have agreed to give us $1.6 billion. Well, that $1.6 billion isn't actually cash. That is the money that Talon owes those creditors. So Talon owes these people $1.5 billion, and they either get nothing or they get a stake in the plant or a stake in Talon's interests. And they chose a stake in Talon's interests. And Talon is using that to say they have great confidence in our business position and our plan. And it says nothing of the sort. So, you know, this is a really quickly evolving issue. It is very complicated, but it is something that we have to pay close attention to make sure that the state doesn't get screwed, that we don't get screwed as Northwestern Energy customers who also owns a plant, and that the place gets cleaned up and closed in a thoughtful way that doesn't screw the workers out of their pensions. For starters, first, second, and third, make sure the people who work there their entire careers get all the money that they deserve. So lots going on with Colstrip, more to come. Derf, it's all yours now to talk about coal.
Okay, hopefully it works this time, and sorry about the technical hurdle there. Let's see here. Okay, can everybody see that? Good to go. Wonderful. Let's show play from start. Okay, as Ann said, I'm here to provide an update on coal mining, and I know this meeting is scheduled to go till, I believe, about 6. So that's a tight time frame in which I can really provide much in the way of really sort of general things, because we actually have a lot going on with coal mining in Montana and coal mines that we work on. But I'm going to zero in on a couple mines and talk about some of the work that we're doing at those particular mines. But big picture, just so people understand, there's currently four big operating coal mines in Montana. We got the Rosebud coal mine, which is the mine that produces roughly, 6 million tons right now and feeds the Colstrip coal-fired power plant. We have the Bull Mountain coal mine, which is produces a little bit less than that, which is located directly north of Billings. It's Montana's only underground coal mine and is fraught with any number of bizarre criminal activity. Google Bull Mountain and you'll go down a Google rabbit hole. There's also the Spring Creek coal mine, which is Montana's largest coal mine and Right across the way is the Decker coal mine, which recently closed. Those two are in southeastern Montana. And like I mentioned, Decker recently closed. The Absaloka coal mine on the Crow Reservation and the Savage coal mine, which is a small lignite coal mine that used to feed the Lewis and Clark coal plant, which is no longer in operation. So I believe that the Savage mine is closed. It may be producing a little bit for the sugar beet factory there, but for coal production for combustion for energy purposes, it's not mining much coal. So, and I'm going to be talking today just about the Rosebud coal mine and the Bull Mountain coal mine, because we have some significant events that I wanted to touch base on. This here is a picture, an aerial photo of Rosebud. And in fact, this is probably about 10 years old. And so it may not look like this in terms of both where the mining head wall is, as well as where the reclamation status is. Things have changed a little bit. But if you're looking the bottom left of this picture, that would be what we call Area B, which I'm going to be talking a little bit more about here in a few minutes. And if you look in the top right, way off in the distance, in the green would be what we're calling Area F. And both of those are expansions of the Rosebud coal mine that we have decided to engage in. This is Area F. And this particular expansion would add approximately 70 million tons of coal to the mining plan at Rosebud. And we obviously have some concerns. This is a greenfield expansion into a really beautiful area. And it's a rather massive expansion. We actually did a lot of work and decided to challenge this in both federal court as well as through an administrative process at the Board of Environmental Review at the Department of Environmental Quality. And just recently, in fact, February of this year, we received an order from a federal magistrate regarding that challenge of this expansion in our favor. The order was in our favor on a variety of different grounds. Some of the most important being that the mine failed, really the Office of Surface Mining and the mine by extension failed to take a hard look at the climate change impacts associated with this expansion. In particular, they failed to actually utilize the social cost of carbon in analyzing this expansion. They had some really faulty reasoning as to why they chose to go down that path. They also failed to really assess the cumulative impacts associated with water. This expansion, coupled with all of the previous historic mining that has gone on, has really hammered the prairie streams out there and caused a lot of damage. And OSM went into it with blinders, as usual, and did not really consider the full scale of the impacts. A pretty phenomenal, strong decision. The decision still needs to be basically ratified and approved by the federal judge, Judge Waters, because the magistrate basically makes a recommendation. And so that's where this case is at this point. However, what we're hoping for is that Area F ultimately will never be mined. And that is our goal here. We want to see this particular part of the country preserved. And the 70 million tons of coal remain in the ground. And as I mentioned, there's also an accompanying BER challenge to this, and we're currently still waiting on a decision on that. It's been sitting at the Board of Environmental Review for almost an entire year since we argued that case in front of the judge last summer, or the hearing examiner rather. And so more to come on that. And then additionally, not on this slide, I don't have a slide for it, but many of you have probably seen in the news, there's also a challenge to Area B, which is, as I mentioned, a smaller area that's in the bottom left of this photo. Now that expansion would I think it's like 10 or 12 million tons. In the scale of things, it's not much coal, but the actual considerations are really critical and important for setting a precedent in terms of how this mine expands and how it operates, as well as other mines across the country. And we had a slog fest. We've been working on this Area B expansion for about almost a decade, and ultimately appealed a bad decision from the Board of Environmental Review to district court. And just earlier this year, a judge out of Sydney, Montana, found in our favor on every single issue, that they failed to analyze a number of water quality impacts associated with that expansion. A bunch of appeals to the Supreme Court ensued, and they got very procedurally technical. Long story short, it is still in Judge Bidigary's hands, but there will definitely be an appeal of this decision. And so we're not at the end of the road yet, but we have some strong law coming out of this on the need to better protect water quality in the face of coal mining. And it's sort of an exciting area to be working in. And the next thing I wanted to talk about was the Bull Mountain coal mine. That is there we go. The Bull Mountain coal mine is, as I mentioned, Montana's only underground coal mine. It's owned by three different companies, one of them being an international commodities trading firm with potential ties to Putin. Another one who has been involved in a bribery scandal in Ohio, and the executives of these companies have been criminally prosecuted for stealing money, overbilling clients, dealing meth, hiding worksite accidents. It's this whole really torrid history associated with the mine. That's sort of the backdrop, but the mine has made a couple of, or is involved in a major expansion onto both federal land and federal coal, as well as through the as well as private coal. And we've challenged this expansion in federal court. And about a year and a half or 2 years ago, we got an unfavorable decision from Judge Malloy, believe it or not, for the most part. And we appealed that to the Ninth Circuit, arguing primarily that the social cost of carbon should have been applied to this situation, or some sort of evaluation should have been applied. They should have really considered the climate change impacts associated with mining and burning this coal. And I should say this coal is sent all the way over to the Pacific Rim, somewhere where it's burned. And the Ninth Circuit agreed with us that, in fact, the government's unwillingness to really sort of analyze the climate change impacts associated with this expansion, while looking at all of the benefits, is sort of a one-sided analysis that doesn't take a look at the complete picture. And it has been remanded to Judge Malloy based upon that decision. So there will be more here, but it is actually fundamentally a really important decision for coal mine permitting across the country, that we need to consider the actual economic consequences associated with climate change and permitting these facilities. We also have a BER hearing coming up on this particular mine in the next couple of weeks. And I've mentioned the BER a couple times here. It's a rather tough venue for us these days. I don't need to get into the details, but it's been an uphill battle in terms of trying to insert some accountability into the DEQ and the coal mining permitting process. So those are my slides. I'm probably a few minutes over at this point, but I'd love to answer any questions you have. And like I said, this is certainly not the extent of our coal mining work that we're doing. We have a lot more in the hopper, and we'll continue to do so, but I just wanted to give some good examples.
Thank you, Derf. Let's hold, Derf, we're going till 6:15, so we have a little bit more time.
Oh, fantastic.
Let me share my screen if I can. Come on. There we are. I'm going to briefly talk about one other coal plant, the Harden generating station. And the concern that this is a 115 megawatt coal-fired power plant just north of Harden, just north of the Crow Agency. While it's not a really huge coal plant, especially when you compare it to Colstrip, it's a really important story for where we're headed as a country on our energy system, and a very disruptive process that has the possibility of really negating a lot of the climate change gains that we have made in recent years. So it's called cryptocurrency and Bitcoin. And by one account, the emissions that are caused by the generation of cryptocurrency today have already negated all of the gains we have made through the adoption of electric vehicles. Cryptocurrency is a type of operation that Katie's going to throw some stuff in chat, which she probably already did. But cryptocurrency uses an enormous amount of energy for something called proof of work operations. And that means it's kind of an open source where in order to get a Bitcoin, people will race each other to solve a problem to verify the blockchain that Bitcoin exists on. Proof of work is a type of activity in which people are using computers all over the world to solve that problem faster than anybody else and gain a Bitcoin as their benefit. Harden generating station has been taken over by a Bitcoin operation. You can see on this photo here, this is the Bitcoin operation. It is just a building full of toaster-sized computers that are constantly operating, trying to solve the equation faster than anybody else in the world. And they have made an awful lot of money doing that. You see those things on the top, those are fans. It's one of the reasons Montana is desirable for Bitcoin operations, is because we have a cooler climate. And these computers get so hot that you have to cool them down. And so they have these giant fans on the top of these buildings. I'm sure they're using air conditioning in Texas. So this company came under a lot of scrutiny. It's called Marathon Digital Holdings, and they just happen to be publicly traded, fortunately. Most of them aren't. Most of them you will never even know about. But Marathon was bragging on its website about taking over the Harden plant, using all of its energy to generate these Bitcoins. And The Guardian got a hold of that article or that issue, and The Guardian ran a story. And then you had a podcast by Reveal that really did a great job of laying out in the first half the problems with Bitcoin operations and their energy use. In the second half, it focused on the Harden generating station, what's going on there. And then MEIC created a fact sheet on this to try to help you understand what the problems are and give you a sense of how much energy these things use. Marathon decided that it wanted to go to renewables because that's the right thing to do. So they're going to move to Texas by the end of the year and supposedly operate their miners, which are just the computers, they're not actual people, operate their miners using renewable energy because of the climate crisis. But when they were asked, well, could somebody else use the Harden generating station for cryptocurrency operation? The answer was, well, of course they could. And they're leaving behind all of their infrastructure so that another crypto operation can come in right behind them and do the same thing that they just did. Cryptocurrency generally has taken a bath in the last couple months, last couple weeks. And it just shows how volatile it is. We have the federal government finally doing some research, asking for comments, which Earth Justice helped us prepare on the trouble with cryptocurrency and what type of regulatory framework we need in this country. And I would argue the first thing we need to do is do what China did and outlaw it. The second thing we need to do at the very minimum is say that this type proof of work type operation that uses so much energy just simply can't be allowed. These companies have got to transition to something called proof of stake, which uses about 95% less energy. There's a lot of reasons why companies don't want to do that, but I'd be happy to answer those in the questions. But Harden it's getting a lot of national attention, but trust me, it is not the only coal plant in this country that is suddenly coming back to life and providing power for these cryptocurrency operations. It's really troubling. Then the next slide, no, I'm not. Gosh, you guys are looking at my screen in a horrible way. I apologize. We're going to talk very briefly about nuclear. And main thing here is that, MEIC we've kind of been hesitant about taking a position on nuclear because there's a climate crisis and we need low carbon energy resources. But the more we learn, the more we are really worried that people are putting so much emphasis on nuclear someday providing a replacement for plants like Colstrip that they're ignoring what's right in front of our face. So they're looking at something called this new technology called small modular reactors, and I'm sure you probably all heard about them at some point. And the proponents of this technology are really gung-ho. The problem is this technology doesn't exist. It is still in the development phase. It is probably about a decade out before it is available for commercial use. And the cost, these guys are not telling the truth about how much it's going to cost. There is a report done by David Schlissel with the Institute for Energy Economics and Financial Analysis that is really, really good and breaks down one of these proposals by a company called NewScale and whether the numbers that they are using are accurate. And what IEFA and David Schlissel found is, in fact, they're not. They are saying that they can produce energy, you'll see this chart on the right, for $58 a megawatt hour. And that's really cheap, but it is not true. You still, though, even if it were $58 a megawatt hour, you have to compare that to utility scale solar plus battery. That's the orange line. And you can see how that is already cheaper and projected to get even cheaper. The yellow line is utility scale solar without storage technology. And storage technology is just really going gangbusters. It's really an exciting arena. So the idea that we're going to settle for $58 a megawatt hour with a type of energy resource that doesn't even exist yet, that we know has storage issues for its waste stream, and there is no long-term storage that's been developed in this country, and that uses uranium or radioactive materials to generate power. There's just better ways to do this. There's simply better ways to generate electricity than putting too many eggs in the nuclear basket. If the Biden administration wants to go and figure out how to make nuclear work, we are not going to engage at that. Let them spend federal money on it. But Montanans should not be spending money on an experimental technology that is so far off and so expensive. Tomorrow, let me just, let me go back if I can. And then one of the things that the IEFA report shows is, I'm not even going to talk about it, never mind, that the cost is actually much, much higher than $58 a megawatt hour because of the way NewScale created its charts. It's super unrealistic what they've done. Anybody who is interested in nuclear energy, I highly encourage you to listen to the Energy and Telecom Interim Committee tomorrow morning at 9:30. Katie's going to drop a link in the chat. She already did. She's always ahead of me. You can listen in and you can listen to David Schlissel. You can listen to the Utah Taxpayers Association, who is beside itself with how much money their little co-ops down there are spending on this NewScale project. It was supposed to just be like a couple $2 billion. It's up to $6 billion, and they're still a decade away they've had to cut the project in half. It's just crazy. So David and a few other people are going to be giving a presentation on the cost of nuclear tomorrow and alternatives. And anybody who's interested, I think it's going to be a wonderful presentation, and it will be recorded if you can't listen. So you can always go to that link that Katie has in the chat and listen to it, over the weekend. And I would encourage you to do so because, we just don't have time to get distracted with a technology that doesn't exist. We need to solve the climate crisis now, and we have the technology to solve the climate crisis now. And so we should be advocating for those types of clean energy resources and energy efficiency, and move on beyond this conversation about a really controversial technology that may or may not someday come online. So that's all we have. I'm sorry that we took so long. There's just so much to say. I know that a few of us are happy to stay on and answer anybody's questions if you have them. So go for it. You can take yourself off mute and you can ask your question or drop it in the chat. Oh, wow.
And this is Mary Catherine. My question, hi. My question concerns what's happening with the solar panel investigation being conducted by the Department of Commerce. And it's essentially that investigation, from what I've read, has stalled the solar industry in this country right now.
Yep.
A lot of pressure is being brought to bear on the Biden administration to, conduct that investigation as soon as possible. What are your thoughts about this, how it's all going to play out?
I think that the company, I would encourage you to listen to, Carbon Copy has a podcast on this problem. And it does a nice job of kind of laying out the features of the problem. You have a small developer in the United States who complained that China was getting around the ban on Chinese solar panels by dumping their solar panels in other markets in other countries, and the US is importing those panels from those countries. What I read yesterday, there's a new report out showing that in fact this company I think it's called Axiom, they didn't do their modeling or their analysis properly. And so it's the fact that they're making this argument without having the facts behind them about where these solar panels are coming from. One is upsetting, but it is very disturbing. It is really troublesome for the solar industry. It is stalling solar energy development in a really big way all over the country. And the Biden administration needs to step in and tell the Department of Commerce to back off and do their investigation, but at least in the meantime, let these solar panels flow into the United States, because it is really hampering solar development across the nation.
Yeah, it's really bad, and the fact that they may also impose higher tariffs on these panels is also not a good deal. We're in a global economy at this point, and you can't turn it around on a dime,
Right. Oh, Colleen Hines, you asked, what is ETIC? ETIC is the Interim Legislative Committee. So it's made up of an equal number of Democrats and Republicans. They meet about quarterly, every few months. It's the Energy and Telecommunications Interim Committee. They met all day today. We talked about Talon bankruptcy and renewables and this issue of Axiom. And tomorrow they're going to talk about nuclear energy and a couple other things. The Public Service Commission comes and presents to ETIC in the afternoon. That should be interesting. I know there's a lot of questions of what's going on in the Public Service Commission. So ETIC is just an oversight body for energy issues in the state between sessions. So another question that Will asked is, or another question, and Will asked it, what does a Talon bankruptcy mean for Northwestern Energy's share of Colstrip and future operations of the Colstrip facility? That is a great question. Talon and Northwestern Energy have an agreement to share their 30% shares of Unit 3 and 4. And Northwestern has always said that it is protected from risk, and its customers are, because it gets power from both units. I think there's a real possibility that Talon simply isn't going to be able to hold up its end of the bargain with the other owners, and Unit 3 is going to close probably sooner rather than later, because it's owned by a whole lot of utilities that want out. And I think that puts Northwestern at some risk. I think that if Talon is unable to pay its share of cleanup costs, it puts Northwestern's customers at risk for having to pick up a larger share of cleanup. And I worry, and I've heard that the owners are very worried about pensions, because they have been paying into the pension fund for the workers out there for a very long time. And Talon's, its writing in the court simply does not match what it likes to tell Montana legislators. And I feel like we're in a game show where at any minute somebody's going to say, well, the real Talon, please stand up. But if Talon doesn't have the pension money, then the question is, what happens with all the other owners who have already contributed? Are they going to feel an obligation to make that pension fund whole? I don't know. The whole thing is just a big freaking mess. And future operations, I think it causes the plant to close sooner rather than later. That's what I think. But we'll see. Any more questions? Okay. We are past time. I want to say thank you all so much for joining us tonight. We are available. That's we being the Derf and Katie and Melissa and Carrie and me and Melissa Hornbein. We are all here to answer any questions you might have about the work we do, and help you understand why we do what we do and what it is we're doing, because we're busy. And we couldn't do it without you. So thank you all so much for generously helping us continue to do the work we do. We're a member organization and we wouldn't be here without you. So truly, from the bottom of our heart, thank you from all of us.
Thank
Great.
you, everybody.